May it please the court. My name is Charles Lincoln, and I represent the defendant in this case, Vista View Properties, which is the manager of the apartment complex where the incidents occurred that involved this case. Specifically, on January 21st, 2015, the plaintiff in this case was walking from her apartment and was assaulted violently. Plaintiff sues on several theories. One being that the apartment complex owed a duty to her as managers of the complex. They base this duty on the legal concept of foreseeability. Foreseeability has been broken down by our courts into 4 factors that need to be determined in order for foreseeability to be successfully invoked. These 4 factors, plus 1/5 one, start off with this, that there's evidence within the vicinity that a crime occurred. Here, a crime occurred, yes, plaintiff contends, but not really. If we look at it, we're talking about adjacent police beats. Sometimes, if we set up a case ruling like this, imagine if we consider adjacent police beats as considering the entire North Texas area. That can't be a good reason. Let's go to the next one, recency. Well, in the past year, we have some recent events that have occurred that ties us into the 3rd factor, frequency. This 3rd factor is relevant because 6 times. Not really relevant because it had only been 6 times that the plaintiff had been injured. And finally, sufficiency, sufficiently similar crimes. The other 4 of those 6 crimes were property crimes. Members of the jury, property crimes are not violent crimes. There is no foreseeability that the apartment complex could have had a duty to protect from these violent crimes. And finally, the 5th factor is publicity. Opposing counsel will argue that there was publicity because it was on a police record, but can we really reasonably expect that everyone's going to be digging through police records to figure out if there was publicity? Perhaps. Opposing counsel will try to distinguish that point of sufficiency because they admit that property crimes are different from violent crimes. But nevertheless, they will try to say, well, there's a ruling from a court in San Antonio that held that a reasonable, intelligent person could suspect these crimes to lead to other crimes. So a property crime will lead to a violent crime. We contend that those property theft crimes and vandalism crimes do not and cannot be considered to lead reasonably that another crime could have occurred. Granted, were they grand theft auto with felonies and a multitudinous of factors? Maybe, but we are so far away from that. It's barely even relevant. So for those 5 factors, barely in the vicinity, the recency was debatable. The frequency was only 6 times compared to cases that have hundreds of times that courts look at. And the sufficiency of the weren't sufficiently similar, and we couldn't reasonably expect property owners to be going to records while they have to manage the property, they have to do all these things. We argue, members of the jury, that we cannot let this apartment complex suffer for something that could not have foreseeably happened. And for that reason, we ask that you find our client not liable because there was no foreseeability, and that lack of foreseeability did not create a duty to protect the plaintiff in this case. Thank you.